and Deputy General Counsel and Lead Staff Attorney John Cotter. We'll start by taking appearances. I'll start with the Department of Public Service.
This is Dan Burke on behalf of the Department of Public Service. Also participating by phone today is James Porter, the Department's Director for Public Advocacy.
Thank you. And for Otter?
Good morning, Mr. Chairman, and Commissioners. Tom Melone for Otter Creek.
All right, and I believe those are all the parties. I see we have a number of people on the phone who are here as observers. Welcome. As you know, you are welcome to participate by listening. You may not otherwise participate in this proceeding.
Chairman?
Proceeding. Yes.
This is Randy Miller on behalf of Agency of Natural Resources.
I'm sorry. I didn't realize that the A&R was on the phone. My apologies.
Not at all. And I also have, just for the record, Andrew Lickner is our summer law clerk. He's joining us today.
Mr. Lickner, I hope you've had a fruitful summer with A&R.
Yeah, thank you.
Good. All right. You have had explained to you all the procedures that are being used for this remote hearing in the last 30 minutes prior to the start of the formal hearing itself, and understand both the limitations and the rules of engagement, so to speak. If anyone objects to the process that we will be using for this proceeding, please speak now. Very well. I assume that therefore everyone is happy and willing to proceed as we are going along with these remote procedures. The purpose of today's status conference is to determine the best way to proceed in each of the 5 separate cases in light of Otter Creek Solar's June 11th proposal to resolve all outstanding issues with respect to its proposed solar projects in Rutland Town, Vermont. The Commission views these as 5 separate cases. We expect to be issuing separate orders addressing Otter Creek's proposal as it relates to each case. Our goal here today is to get some clarification on some issues and hear from all of you on anything additional that you want to add regarding the process that you believe we should be following with regard to this matters that are in front of us. Mr. Melone, based on the comments, yes? Did someone just speak up? Sorry. Based on the comments you filed on August 14th, you apparently envisioned the issuance of what you call an omnibus order that would apply in all 5 cases, that grants the relief you are seeking without any additional process in any case. Does that basically summarize your position accurately?
Yes, it does, Mr. Chairman. I think that is possible to be done if the Commission agrees with that approach.
Okay. And the Department had a more issue-specific approach in its August 14th comments addressing the various aspects of Otter Creek's proposal. While A&R did not file separately, but it did agree with the Department's position, particularly on the question of what to do with regard to Otter Creek's request to reduce the size of one project from 4.9 to 2.2 megawatts. Mr. Miller, is that correct that A&R, the only issue on which A&R is offering any opinion and it's joining with the Department is on that one question in that one case?
That is correct.
Okay. All right. So I think we will go through this on a case-by-case basis and take any additional comments from the parties now that you've had a chance to see each other's filings from Friday the 14th, and in some cases ask a few questions that we have. We'll try to do this in an order that makes the most sense, because how we handled some of the cases may have implications for how we handle others. So we're going to start with case number 20-0266, PET, the request for a non-substantial change determination allowing the reduction of the 4.9 megawatt OC1 plant to 2.2 megawatts. And Mr. Melone, a few questions and clarifications I'd like to get from you, please. Your petition did not contain a request for an amendment to the CPG as a form of alternative relief. The only request for relief was for a non-substantial change determination. Is it correct that you, at least to date, have not filed a formal request to amend that CPG?
Mr. Chair, my recollection, and I'd have to go back and check, is that we had asked for an amendment as an alternative relief in our petition.
Okay, and that was in your original filing in the case? That is your original filing in the recent times in the case?
In the original, I believe it's in the original petition to reduce the size, but I can go back and check that.
Okay, and when you say the original petition, you don't mean in the original petition when you originally got the CPG for the 4.9 megawatt. You're talking about the subsequent filing when you originally asked the commission to make a non-substantial change and reduce the size from 4.9 to 2.2. Is that correct?
That's correct, Mr. Chairman.
Okay.
Mr. Chairman, can I ask a clarifying question? So,
Yes, please.
Ms. Malone, I was not aware that you had asked for alternative relief. That was your intention, is what you're saying, or you have no problem, you would not object to that being taken as a form of alternative relief?
That's correct, Commissioner Hoffman.
Thank
Now, the petition in which you originally filed included as an exhibit a 2.2 megawatt layout designed to allow the construction also of the 2.2 megawatt OC3 facility. Is that correct? That original amendment or non-substantial change, that layout showed both the new reconfigured OC1 plant and a then proposed OC3 plant. Is that correct?
That is correct, Mr. Chairman.
Okay. Now, the June 11th proposal, the one that we're now discussing today, includes a different layout. Correct?
Correct, Mr. Chairman. Yes. So yes, the proposed plan that we filed with the motion to resolve works with the the footprint that was approved in the original CPG petition, and it just puts a 2.2 megawatt project within that and doesn't make any room for anything else.
And does that new layout preclude the future location of the third project that you propose to abandon as part of the June 11th proposal?
Yes, it does. It precludes that.
All right, and is Otter Creek committing that 2 projects is the limit for this parcel of land, or are you intending to reserve the ability at some future date to seek approval of a third project in this same overall footprint?
We are not. We will not put a third project on that site. We're only seeking approval for the 2 that we originally had CPGs for, and that we're asking for now, that are shown in the amended plan. So it's just 2.
Right, and just so I'm clear, with the amended plan, is there enough space there if somebody, not you, but if somebody wanted to put another 2.2 megawatt plant on that same overall footprint? Is there room for them to do that, or have you configured the proposed new OC1 and OC2 in such a way that that would not be possible?
That would not be possible. The only type of additional solar array that could be built there would be maybe a 20 kilowatt project if somebody wanted to do that. But, yeah, that's pretty much it.
I have a question.
Yes.
So when you say it would not be possible, is it because of the reconfigured layout of what is now the 2.2 OC1?
Yes, that's correct. Commissioner Cheney.
In the June 11th filing, was there any testimony that supports use of the new layout?
I don't believe we submitted any testimony with the new layout.
And what is your position on whether or not there needs to be testimony on all of the usual 248 criteria with regard to the new layout for that 2.2 megawatt project?
Well, our position is that since we're using the identical footprint that was approved in docket 8797, and we've kept everything the same with the only exception of putting fewer modules there now. So my view at least is that the impact is by definition less than what was approved because we're just going to be fewer modules in the location that there's a CPG for.
Okay, so are you saying that the extent for it, let's sort of talk about the issues. So to the extent that there is ground disturbance, you're saying that the type of ground disturbance and its location be no different, but conceivably less, with the new proposed layout than it was for the original layout that we approved many years ago?
That's correct, Mr. Chairman.
Okay, so we're talking about the same posts, the same either undergrounding or above grounding of the lines, the same location of the transformers, the inverters, et cetera, et cetera. Is that correct? Do I understand that?
That's correct.
I have a question to follow up to that. We were talking about how there's a new layout, and which by implication is a perhaps more spread out layout if it precludes the ability to build a third project there in the future. So how is that then the same posts, the same layout, the same impact as before? Could you explain that?
Well, it's either the same impact or less. So there would be less modules, less posts for the racking. The fencing posts would be approximately the same because the fence is going in pretty much the same place around the transformers would be the same. I mean, it would be less in terms of the actual racking. It would just be more spread out.
And just to be clear, although we were asking these questions here, and you've been very good about giving us useful answers, we don't actually have any kind of a comparative layout that sort of shows us what the new layout looks like, if you will, kind of superimposed on what the old layout was that approved several years ago for the project, correct?
Correct. There's no superimposed layout.
Okay. Has there ever been a petition filed by Otter Creek with supporting testimony and exhibits seeking an amendment to the CPG issued in case number 8797 that would allow the reduction of the 4.9 megawatt project to the 2.2 megawatt project depicted on the site plan that was filed on June 11th.
In our original, in the original petition in docket 20-0266, I believe we included testimony on all the factors in, under 248 for what would have been the shrunken layout to accommodate the third project. So that testimony did not address this new revised layout. But we did, I believe in that original petition, ask for the alternative relief of an amendment if the commission thought it was, or that it could not consider it a non-substantial change.
And did that testimony and exhibits include a new environmental analysis of the site, given that between the time that the original 8797 application was filed and processed and the date when the new application or request was filed, thus that the site had been cleared, and therefore that the natural environment was different? Did this new supporting testimony and exhibits that were filed in 20-0266 involve a new environmental analysis, or did it rely on the prior environmental analysis?
Yeah, I think it did both, because that was one of the questions that wasn't clear, or that the commission had a question on from the original petition in 0266. And I believe there's subsequent affidavits that were filed to make it clear that the environmental opinions were being given based upon current condition of the site, or the then current condition of the site.
Okay. And Mr. Miller, just so we're clear on what A&R's position is, does A&R have some environmental questions that they think have not yet been answered by this testimony and exhibits that Mr. Melone has just referred?
Yes, the agency's position is, based on the new layout, the agency would need to reevaluate, the natural resource impacts, as opposed to what was already included in the previously issued CPG.
And am I correct that the agency itself has not yet undertaken such an analysis?
No, not at this time.
And have you and Mr. Melone, or has your department and OCS had any conversations about what concerns you might have and how you might resolve them, or has that not yet occurred?
That hasn't occurred while I've been on the case. I can't speak to the prior attorney that was handling, but I don't believe so.
Okay. And Mr. Melone, is this correct that at least to date, you and A&R have not discussed any of these questions that they have about the new layout with regard to this 0266 project?
That's correct, Mr. Chairman.
All right. Commissioner Hoffman, Commissioner Cheney, do you have any additional questions for Mr. Melone or any of the other parties on 0266?
I do have one, which is I cannot find, Mr. Melone, where you requested an amendment. I do see where you requested the non-substantial change. Can you give me a date for that, or check that to make sure you're correct? I cannot find that.
Yeah, while we've been on the phone, I've been trying to pull up the original petition that was actually filed on EPC, and it doesn't seem to be there.
All right, Mr. Malone, while you're still looking, Mr. Burke has his hand up. Commissioner Hoffman, maybe Mr. Burke has an answer.
Well, sir, Commissioner Hoffman, I think I might be looking at the same document as you. I pulled up a document dated January 30th, 2020, which it doesn't ask for any alternative form of relief in this docket. I know there were subsequent filings, which I haven't looked at, and this document does represent that there was affidavits filed by several witnesses on behalf of OCS, consistent with what Mr. Malone otherwise said about this. Yeah, I don't see that alternative.
That's very helpful. Mr. Melone, would you have any objection to filing such an amendment? Asking for such an amendment?
No, I would not have an objection. I'm being told by my son that we did not, in fact, ask for alternative relief in the original petition. We did ask for it in our motion, though.
But your motion meaning the June 11th filing now?
Actually, motion consider. If I could just have a minute. But in any case, we would be prepared to submit a further request. That's what the commission wants, to make it clear that we are prepared to seek alternative relief as an amendment.
Okay, thank you. Thanks for clarifying that, Mr. Malone. Commissioner Hoffman, anything further?
No, that was helpful. Thank you.
All right, Commissioner Cheney?
No, I agree. That was helpful. Thank you.
Okay, and Mr. Burke or Mr. Miller, do you have any other questions or issues or statements you want to make with regard to 20-0266? Mr. Burke?
One thing I would just like to add, I know in the comments we filed, I think it was on June 11th, we advocated for requiring Otter Creek to file a new petition requesting an amendment. And I don't think we'd be opposed to reviewing a requested amendment within this proceeding, just so long as when that is filed, adequate notice is provided to all the parties entitled to notice under 248 and Rule 5.407. That's our primary concern here, is that everyone that is entitled to notice, and all the state agencies, the Rutland Town Plan boards, and any members of the public have adequate notice to participate in it. That's our principal concern.
Okay, thank you. And Mr. Miller, on that particular question, what is A&R's position?
The agency joins with DPS.
Okay. And do you have any other questions or comments you want to make as to 20-0266?
Nothing further from the agency.
Okay. Then unless there's any other questions, we can move on to 20-0625. This is the request for relief from the petition filing and commissioning milestone for OC1 standard offer contract. Mr. Burke, I have a couple of questions for the department. Do you believe the commission needs any additional information from Otter Creek other than the possibility of information related to the new site plan to make a decision on the requested extensions?
I don't believe so, Mr. Chairman.
Okay. And what about the lack of a timely petition for the 2.2 megawatt OC1 project? Is that something the commission needs to address or be concerned about?
When you say timeliness of the application, you mean within the constraints of the milestone in the existing standard offer contract?
Right.
I think it's a consideration that the commission has to take under advisement. It's an issue that we litigated with the Malones in that prior proceeding. You do have an evidentiary record on that issue, but yes, you would have to consider that, whether or not they did have a timely application.
But
you do have the authority to amend that milestone.
Okay. And in your view, we have all the information that the department thinks we need.
Excuse me, I'm sorry. You said you have the authority to what?
To amend that provision within the standard offer contract.
Okay, thank you.
All right. My apology. I think I overspoke Mr. Burke. Excuse me. Mr. Burke, so the department's view is that we have the information we need to resolve that question, but that we do need to resolve it.
Yeah, that would be that would be the department's position. But you also, at the same time, if you felt that you needed more information, that's also within your discretion to remand that back to the hearing officer or simply to open the evidentiary record sua sponte.
Okay. And Mr. Melone, I take it your position is that we have all the information we need to resolve the issue raised in 20-0625. Is that correct?
That's correct, Mr. Chairman.
Okay. And just to make sure that I don't again neglect you, Mr. Miller, A&R doesn't have a position on this. Is that correct?
That's correct, Chairman.
Okay. All right. All right. Now the next cases number 20-0253 and 20-0233. These are the Otter Creek's petition for an OC3 project and its petition for an extension of the commissioning deadline in the standard offer contract for the OC2 project. So here are the questions that the commission has with regard to the please excuse us, but we are getting a little confused occasionally here. I will attribute that to us, not to you, but we would like some clarification. There seems to be some confusion, at least in the initial filings, related to the June 11th proposal on how things would work with regard to OC2 and OC3 projects, CPGs, and contracts. I want to be clear on what the parties' understanding is for these two projects. So let's start with you, Mr. Melone. What exactly are you suggesting happens to the OC2 and OC3 projects if what you've asked for is granted?
So at the end of the day, Mr. Chairman, the petition for OC3 would be dismissed or be withdrawn. And then the standard offer contract in 0233 would be extended, and the address in that standard contract is the same address as the OC2 project. So what would happen is, in effect, we would build the project that was approved in docket 8798, and we would use that project as the project under the OC3 PPA.
Okay. Mr. Burke? What's the department's understanding? Is that understanding what you have as well?
That is our understanding, that they are not making any modifications to the OC2 project that would require an amendment of the Certificate of Public Good. It's also our understanding the site access issues that were the subject of the prior litigation, that it's now pending before the Supreme Court, have been resolved. And so that site access issues subject to remedy on the rule violation have been resolved for site plan purposes going forward.
Okay, and by the site access, you mean that the proposed site access that was originally in question because it wasn't clear that OC had access that way, that's now been resolved between Otter Creek and the owners of the necessary property, resolved in that way, correct?
Yeah, it's our understanding they have the legal right to access the property from the alternate location.
Okay. And Mr. Melone, it is Otter Creek's intent, if all of this is approved, to use that access for the construction of what would then be Otter Creek 2.
That's correct, Mr. Chairman.
Okay. All right. And just to be clear, if the June 11th proposal is accepted, then your position, Mr. Melone, is, and I think you said it before, and I don't want to fail to get it clear, the Otter Creek 3 project will be abandoned either by your withdrawal or our dismissal of the petition with prejudice or whatever, but it's going to go away, correct?
Correct, Mr. Chairman.
Okay. Now, there is a standard offer contract for Otter Creek 2. Is it your intent, again, if the June 11th proposal is accepted, that the Otter Creek 2 standard offer contract will also be abandoned?
That's correct, Mr. Chairman.
Okay. All right. Commissioner Hoffman, do you have any questions with regard to these two cases and the issues that they present?
No, thank you.
Commissioner Cheney?
No, I do not, thanks.
Mr. Burke?
No further comment, Mr. Chairman.
Mr. Miller?
Nothing further from the agency.
Okay. All right. All right, and then we go to case number, excuse me, case number 20-0440. This is Otter Creek's request for an extension of the petition filing milestone for the Otter Creek 3 standard offer contract. And Mr. Melone, just so I'm clear on this, you need that extension of the milestones for the standard offer contract for Otter Creek 3 in order to be able to use Otter Creek 2 to fulfill that contract, correct?
That's certainly one way to approach it, Mr. Chairman. I think if the other way is just to treat the CPG from 8798 as satisfying the milestone once the commission decides what to do.
Okay, so in other words, if the commission decided to essentially call Otter Creek 2 the fulfillment of Otter Creek 3's obligations, then the Otter Creek 3 CPG would have been fulfilling the Otter Creek 2's obligation to have a CPG. Did I get that correct?
I think if you just switch around, the OC3 and OC2, it is correct.
The next time around, maybe more descriptive
Right.
names would be helpful, right?
Right. Well, it's what we were trying to do with the intent to rename the project to avoid this problem in the future.
All right. Does the department agree with the OCS request that the OC3 contract should be transferred to the OC2 project?
We don't object to that process in the abstract. I think Mr. Malone's right. These projects are at the same E911 address, and I don't think it's a legal impediment to make that transfer. Our perspective, though, is that they should be filing a separate petition to amend that standard offer contract to make sure that the Schedule A is crystal clear as to which project it's referring to, and we think that there should be a separate extension request and a different proceeding. So you parcel those two together instead of having two separate proceedings and reviewing the same standard offer contract in two separate proceedings. Going back to a similar issue I said earlier, if the commission feels that they could remand this and reopen the evidentiary record and restart within that proceeding that's already open, we wouldn't be opposed to that. But we do think that there needs to be more information and evidence in front of the commission, and that that contract would need to be amended, at least the Schedule A component of it.
Mr. Melone, do you agree or disagree with what the department has just said? Or are you willing to accept what they have just said?
We are willing to amend our request so that we include an amendment to the Schedule A, where we could make it clear as to what project is going with what PPA. I don't think we need to open up a separate docket, but again, if we need to do that, then we're prepared to do that as well. I think it would be easier to resolve it by just amending what we've already filed, just to make it clear that this is what we're asking for. We're going to ask for, we would attach the plan from 8798 and say we would like the Schedule A of the PPA to be amended to include this plan so that everyone knows.
Mr. Burke, if Mr. Melone did that, would that satisfy the department, or is there something else that you would also want?
Yes, it would. And it also just goes back to making sure that all parties entitled to notice have it. In this case, that would be the distribution utilities. They receive notice, I think, for all standard offer contract modifications automatically through EPUC. So as long as that process is followed, we wouldn't have an objection to that.
Okay. And Mr. Miller, am I correct that A&R does not have a position on this particular issue?
That's correct, Chairman.
Okay. Now, Mr. Melone, has Otter Creek ever filed a request to extend the commissioning deadline in the original standard offer contract that's the subject of 20-044Z0?
Well, I think the only request to extend the commissioning deadline was made in the motion to resolve. I don't think there's been any other formal requests before that, since we had the issue with the CPG milestone.
Okay, and what is your understanding of what the current commissioning milestone is under that contract in light of all the various activities that the commission has taken with regard to the impacts of the COVID-19 emergency in the state?
I think all the commission's extensions applied to contracts that would have had a commissioning deadline by the end of this year, as I recall. And each project was given a one-year extension. Our commissioning milestone, as I recall, is in January 2021, so I think we would fall outside that right now, once the commission extended those milestones.
Okay, but am I understanding correctly, at least today, the only proposal we have is to extend that commissioning deadline. We have some disagreement as to whether it's January 29 or January 30, but we're not going to spend any time on that.
Right.
We know how many angels can stand on the head of that pin, but that you've asked that it be extended, and what is the basis that you've offered for why you think you need that extension, assuming for a moment that the commission were to otherwise approve what you've asked for in the June 11th proposal, and that in relatively short order you had the green light to build that project?
Well, I think the reason is I think at this point, unless we had a green light by next week, it will be all pretty much impossible to get the project commissioned and built between now and January. We would be able to potentially start, but we'd have to go through the process of getting a contractor, which itself normally takes a month or two on its own. Then they'd have to order the equipment. We have modules, but we don't have the racking. So we'd have to order racking, transformers. Generally, lead time is 20 weeks or so. So that that in of itself would put us by pretty much to the end of January. So I don't think it'd be possible to actually construct it, though we would start the process right away. And of course, trying to construct it in the winter in Vermont is not the easiest task either.
I'm sorry, go ahead.
Yeah, so I think that's why we asked, I think in our questions or in the motion to resolve for an extension of a year from whenever the Commission's order would become final.
And this information you just shared with us regarding which equipment you do, which equipment you don't have, and the reasonable time it might take to get a contractor, transformers, et cetera, was that put into the record yet in the request that you made on June 11th, or is that information that has not yet been formally presented?
I do not believe that's information that's been formally presented right now.
Okay. All right. Commissioner Cheney, do you have any questions for Mr. Melone or for the department?
Yes, if you could clarify, you mentioned at first in addressing this topic that you would need a green light by next week, and then you went on to describe the equipment that you do and do not have and the lack of a contractor ready to go right away. So does that mean that even if you did get the green light, you would still need an extension to commission before next year?
I think it would be likely. The best case scenario, I guess, would be that we could get the racking within 8 weeks. That would put us at the end of October. We might be able to get the ground screws before that, so they could start installing. It would be, I wouldn't say it's impossible to get it done by January 30th, but I think it would probably end up being likely that we would need some extension in any event. And because of the pandemic, it's tough to get or to count on the actual time frame to get people to build projects. We're doing fine now in Connecticut, but still, there are delays.
Commissioner Hoffman?
Yes, Mr. Malone, this is going to sound probably more pointed than it is, but in one of your previous oral arguments, you had indicated that all the equipment was ready to go, was sitting in your warehouse. So when you said that, you meant only the modules were in the warehouse?
That's right. The module. Well, yeah. We have since deployed some of those modules. We have enough modules to do the Otter Creek. To do these two projects, but we don't have the racking.
Okay, thank you.
Right.
Okay. Mr. Burke, any questions or comments with regard to this discussion?
I have no further comment on this case.
And Mr. Miller?
No comment, Commissioner.
Okay. We're going to briefly discuss among ourselves what we've just heard, and what we would recommend is that everybody turn off your cameras and turn off your microphones. We will stay on the line, and we will come back on after we've had a chance to speak among ourselves. Don't disconnect from the GoToMeeting, and this should be maybe 10 or 15 minutes, and then we'll come back and have some further conversation with all of you. Thank you. This has been very helpful. I don't want to neglect Mr. Otter. Are there any questions that you felt were needed to be answered that we haven't gotten answered yet this morning?
No, I don't think so. I think that was very comprehensive and very helpful, and I think Otter Creek gave us a lot of good information, and that's appreciated.
Okay. Mr. Cotter knew that these were all the right questions because he helped us develop them. So thank you, Mr. Cotter. So we're going to go off and talk among ourselves, and we will be back when we can. Okay. All right, I think we're all back. Suni, are you ready to go?
Yes, I am. Thank you.
Okay, thank you. If you wish, you can note in the record what the was between when we ended and when we came back on the record. Great. Okay. We've considered all the parties' comments. Thank you again very much. And we're prepared to make some decisions today, although not necessarily resolving everything today. With regard to the question of what to do about the reduction of the CPG in 8797, we believe that this needs to be filed as a new case in EPUC seeking an amendment to the CPG issued in that case, seeking to authorize the construction of a 2.2 megawatt facility. The petition must be supported by exhibits and sworn testimony or affirmations by qualified witnesses explaining why an amendment is appropriate, that is, why there will be no undue adverse impact under any potentially impacted Section 248 criteria specific to the layout included in the June 11th filing. All original parties to case number 8797 must be served with the petition, as well as any entities or individuals who would have been entitled to service of the original petition. The Commission will seek responsive comments and set a schedule for further process as needed based on any comments received. We strongly encourage Otter Creek to work with other parties to reach mutually satisfactory solutions of any potential issues to avoid unnecessary delays in our review of the petition. As part of this petition, OCS should clarify whether the reduction is still being done to accommodate a third project on the parcel, or whether it is abandoning those plans. The purpose of new proposed layout should be explained and why it is different from the layout proposed in case number 20-0266-BET. Secondly, we believe you should file as a new case in EPUC a petition seeking the transfer of the OC3 standard offer contract to the OC2 facility. We want you to know the Commission is inclined to approve that petition, but that the process for obtaining our approval requires that you actually file the petition in EPUC. If OCS is also seeking an extension of the commissioning deadline in that contract, it must specifically include it as part of this petition and provide full justification for why the extension is warranted. So while we're inclined to treat the petition obligations under the standard offer contract as being met, we are not at this point prepared to grant the request that the extension of the commissioning deadline is automatically granted. We'll seek comments from relevant persons and entities, and will determine what additional steps, if any, are needed in response to any comments we receive. As part of this petition, OCS shall explain why it is seeking to transfer the contract to the OC2 project and what its intentions are regarding the OC2 standard offer contract that is the subject of case number 20-0233-PET. With respect to the petition filing and commissioning milestones in the standard offer contract for the OC1 project, we believe that we can resolve those issues within the existing case number 20-0625 based on the information we have. Do any parties want an opportunity to file additional comments? Mr. Burke?
The department does not.
Mr. Melone? You're muted.
No, Mr. Chairman.
Mr. Miller?
No, Mr. Chairman.
With respect to the petition seeking to extend the petition filing milestone in the standard offer contract for the OC3 facility, we believe that we can resolve those issues within the existing case number 20-0440 based on the information we have. Do parties want an opportunity to file additional comments on that question? Mr. Burke?
The department does not. Thank you, Mr. Chairman.
Mr. Malone?
No, Mr. Chairman, we do not.
Mr. Miller?
No, Mr. Chairman.
It's possible that we would issue a joint order in both case number 20-0440 PET and a new case seeking authority to transfer the OC3 contract to the OC2 project and any request for an extension of a commissioning milestone in that contract. Does any party object to us following that procedure should we decide that's appropriate? Mr. Berg?
The department does not object.
Mr. Malone?
We do not object, Mr. Chairman.
Mr. Miller?
The agency does not object.
Okay. This leaves the issue of what to do about the two cases that are on appeal to the Supreme Court, case numbers 19-1596-INV and 19-3031-PET. We agree with the department that we can address all other elements of the OCS proposal without addressing the resolution of these two cases. OCS has suggested that instruct the parties to seek a remand of the cases from the Vermont Supreme Court so the Commission can entertain the proposed penalty amount as part of an overall resolution of all issues related to OCS's proposed Rutland project. We decline to follow Otter Creek's recommendation. It's up to Otter Creek to decide whether to seek a remand of its appeals or, absent a directive from us, that it do so. Whether it still wants us to consider its proposal independently of those two cases. If Otter Creek chooses to pursue its appeals, we will still consider its proposal as it relates to the 5 cases we are discussing today, if it wants us to do so. Decide those issues independently of the matters on appeal and react to whatever decision of the Vermont Supreme Court ultimately issues. If Otter Creek decides to seek a remand of the 2 cases that are now pending in the Supreme Court, Otter Creek should immediately inform the Commission and parties that it intends to do so and state whether it believes the Commission should suspend consideration of the other aspects of its proposal while we await a remand order from the Vermont Supreme Court. This would, of course, delay resolution of the cases that are not on appeal. Do we have anything further that we need to discuss today? Mr. Malone?
No, Mr. Chairman, unless you would like me to give some response to what you just said on the Vermont Supreme Court cases.
If you have something that you wish to say, please do so, Mr. Malone.
We would be prepared to seek a remand from the Vermont Supreme Court. My guess is that the Supreme Court would only agree to that if it was supported by the department. But in any case, regardless of the process for those 2 cases, we would still ask the Commission to proceed with the consideration of the other 5.
Okay.
I think we represented in our prior filing that we would not object to any request for a remand from the Supreme Court, and that position has not changed. Mr. Malone, I know you have a briefing deadline coming up in the relatively near future. in those cases. So that's a discussion that we should probably have offline as to how to present that to the Supreme Court. But no, we would not oppose any request to remand in those cases back to the Commission while these subsequent requests remain pending before the Commission.
And Mr. Burke, the department is okay with us proceeding to decide the other 5 cases, irrespective of how those 2 cases that are on appeal are ultimately handled by the Supreme Court, correct?
Correct. From our perspective, the only issue that remains outstanding with those 2 cases is the penalty amount, and I think that's sufficiently independent from the other issues that they could go for. Those other 5 cases could proceed for. Yes.
And Mr. Miller, does ANR have any position on these questions?
No, Mr. Chairman.
Okay. Is there anything else that we need to discuss today?
None from Otter Creek's perspective, Mr. Chairman.
Mr. Burke?
I have nothing further. Thank you, Mr. Chairman.
Mr. Miller?
Nothing further from the agency, Mr. Chairman.
All right. Thank you all very much. This has been informative and useful. We appreciate your time and your professionalism. Oh, yes, Mr. Cotter.
Yes, Mr. Chairman, excuse me not to interrupt, but I think I would just remind the parties that it was the Commission's intention to memorialize today's decisions in the form of a written order, and we would be issuing that as soon as we can get it drafted and issued.
Yes. Thank you, Mr. Cotter. And that will be coming out shortly, but I think you know from what we've said today what the conclusions will be, and you can proceed to act based on those. Thank you again for your time, and this hearing is adjourned.
Thank you, Mr. Chairman and Commissioners.
Thank you.
Thank you.